Ripple's fight against the SEC continues to yield one victory after another. Will this be Ripple's last chance to win? Will the SEC be able to turn the situation around? To discover out, watch the video until the conclusion. But first, at the end of the month, we'll give away $25 to one fortunate subscriber to help them get started with XRP. All you have to do is click the like button on the video, subscribe, and leave a remark in the comments area with your opinion on XRP. Hello and welcome back to the XRP Army. Let's help the XRP Hut community flourish by liking and subscribing. After learning of an email sequence between the SEC and a third party, Ripple was able to prove that Hinman's 2018 speech was not just his personal perspective, but also in accordance with SEC laws. The judge has requested that it be reviewed. Former SEC Director William Hinman has been at the center of the controversy since delivering a well-known lecture in 2018 in which he announced that Ethereum is not a security, leading the price of ETH to surge. Ripple's legal team discovered descriptions from the SEC privilege log that appear to be particularly relevant to this issue, and they believe these descriptions are correct. According to one email conversation, the complaint is about concerning talks. The SEC sent an email to a third party telling them to examine a digital asset using the factors mentioned in Hinman's speech, which speech was just his personal opinion. The SEC sent an email to a third party telling them to examine a digital asset using the factors mentioned in Hinman's speech, which speech was just his personal opinion. I understand now it's the SEC that needs clarity, said attorney Jeremy Hogan at the time, alluding to the agency's contradictions. In other circumstances, the paper might be used to specifically prove that Hinman's remark was not only a personal view, but was also in accordance with SEC policies. This has been a major topic of contention throughout the trial. Even more crucially, if the judge finds that the SEC spent the entire time stating that Hinman's comment was merely his personal view while simultaneously making recommendations based on that speech, the SEC will be in a tough position for the remainder of the legal proceedings. Judge Sarah Netburn released a breaking news earlier today, announcing that Ripple's request had been granted and that the papers and email chain would now be included in the in-camera review. The defendants are requested approved. The SEC must provide the two papers pertaining to the SEC meetings with law firms and the email chain for in-camera review by October 15, 2021, along with a filing outlining its privilege assertions for each of those documents. On the public docket, the SEC will file a redacted version of its submission. The defendant's response is expected by October 22, 2021. As ordered, Ripple has just filed a new answer to the same action, and it is unclear when the court will complete his review. In the meantime, render a decision on the SEC deliberative privilege process problem. Defendants, represented by Matthew C. Solomon, they claim that the deliberative process privilege, DPP, does not exist because the Securities and Exchange Commission, SEC, has never examined a digital asset policy. Because of Ripple's counsel's activities, the SEC is obliged to choose between two options. A DPP lawsuit has been filed against the SEC because its employees' opinions have become policy. However, Hinman's comments and those of other SEC officials can be used, provides evidence against the SEC in a lawsuit filed by investors against the agency. According to Hinman, the concepts expressed by its officials, including those conveyed in his speech, are simply personal beliefs, and hence no claim to deliberative process privilege can be established in the context of digital assets. According to sources, a Securities and Exchange Commission memorandum relating to a legal study of XRP was distributed to select SEC employees on June 13, the day before Hinman's lecture. The decision on the privilege question will be made by Judge Sarah Netburn. However, the SEC has previously been ordered to turn over many of the records to Ripple's attorneys, and despite the judge's orders, the agency has failed to comply. Ripple has filed a contract breach lawsuit against the SEC. Do you think Ripple will finally win because of this achievement? Please let us know in the comment section below. There's little doubt that the SEC is firing its last shot, and the financial watchdog's future appears gloomy at the moment. Despite the fact that the expert discovery date has been extended to November 12, it appears that Ripple will prevail in the long-running SEC vs. Ripple lawsuit. Also worth noting is that one of the most contentious issues in the lawsuit is the recordings of internal meetings that Ripple was required to make available to the parties. Ripple search algorithms have already been chastised by the Securities and Exchange Commission, SEC, who described them as flawed. Furthermore, the regulator demanded pre-motion conferences in order to compel Ripple to produce the disputed recordings. Ripple has now provided three significant grounds for its position that the SEC request should be denied. The following are some of these arguments. Ripple Labs lawyers argued in a letter made on October 8 that the fact discovery. Furthermore, despite the fact that the SEC had not yet approved such procedures, Ripple search algorithms for its recordings had been authorized. The petition later said that Ripple had fulfilled its duties by conducting the earlier search, which was supported by evidence. According to the firm, it would be difficult to uncover any additional records unless it analyzed more than 4,000 recordings in total. The petition also emphasized that Ripple conducted a comprehensive and reasonable search. Ripple also claimed to have generated 170,000 papers as part of their case. Approximately 1 million sites that were relevant to Ripple targeted search phrases. Also, make a point of writing down your thoughts on Ripple's reasons provided in the comments section. Ripple's earlier productions include hundreds of documents that show that the substance of many internal meetings, including meeting agendas, slide decks, presentations with comprehensive speaker notes, and summaries and discussions of the sessions, is stated. The lawyers also claimed that additional unreleased recordings were duplicative of the original and should be removed from circulation. The SEC boiled the ocean requirement is patently irreconcilable with the federal rules, and given the huge volume of material already provided in discovery, the SEC request is unreasonable. According to the paperwork, the SEC claimed that it refused to search the contents of the documents. Ripple also disputed the validity of some recordings, claiming that this was a violation of the law. According to a footnote in the study, the SEC, and this was supported by other sources. So, how much will Ripple be worth if it wins in the end? I believe it is worth the amount of Ethereum that it costs to buy. XRP, on the other hand, is unlikely to have obtained the same exemption merely on the basis of its utility. And we'll never know because the winners have already been determined. The SEC and the crook who stole the Ripple technology have messed over all other tokens. As a result of the thief's theft of Ripple's technology, the entire worth of Ethereum would be Ripple value rather than the thief's value. What are your thoughts on Ripple's chances with this latest victory? Will it truly be worth as much as Ethereum if it wins the case? Please let us know in the comments. If you want to learn more about XRP, we have 2 videos waiting for you at the bottom of the page. Please subscribe and give us a thumbs up. Thank you very much for taking the time to watch. Look forward to seeing you in the future video. Please keep in mind that cryptocurrency prices change rapidly, so by the time you see this video, it may have changed to a completely different value. The information in this video does not represent investment advice, financial advice, trading advice, or any other type of advice, and you should not take any of it as such. This video's information is intended solely for educational purposes and should not be construed as financial advice. Execute actions before making any investment decisions. Conduct your due diligence and consult with your financial advisor.